And then after we go live, why don't you?
We are live.
Okay, thank you. And Matt, why don't you make sure you're muted so that if you can ask questions to Dylan. All right.
We're good.
This is the thank you for and welcome to the second or third meeting of the Civil Law and Procedure Subcommittee. We now have a quorum. We're going to invite Mr. Wilson in to be able to help us through the amendment. We're just dealing with House Bill 18, Delegate Hill's bill on power of attorney. And as you will recall, we've already passed amendment number 1, which was a clarifying amendment to make sure that that it's specified that it's governmental entities and that they can make the gifts can be made to specific entities, which I don't have it in front of me, but that was amendment number 1. We've already passed that. Mr. Wilson, it's great to see you. Thank you for being here. Mr. Wilson was a member of the work group from the Estates and Trusts section of the bar. Is that correct, Mr. Wilson? You can unmute yourself.
Yeah, sorry about that. I just didn't want to be
and
going ahead. So actually,
no, I'm going to give the floor to you in a second. Go ahead.
I just wanted to say it wasn't just the Estates and Trusts.
I was going to give the floor to
council,
you, and
it was also the Elder Law Section Council. So
great. So I think we would love for you to just quickly walk us through. First, tell us what the task force or the work group, it met through the interim to create a this legislation. So you can just describe that very quickly and then go through the amendment if you can. Okay.
So we actually started on this. We're the same working group that worked on the Maryland SAFE Act that was passed in 2021. And we actually started in 2021, hoping to get the work done by last session. But I'm sure that more than one of you is a lawyer, so you're probably familiar. If you put 6 lawyers in a room, you're going to get at least 10 different opinions on things. So it was a working group of lawyers, like I said, both from the Estates and Trust section and from the Elder Law section. And I'd mentioned that because even though elder law attorneys do estate planning, we take it from a different angle. Usually our clients are older. Usually the client base for estate planning attorney, many estate planning attorneys, is a wealthier client base. The client base for elder law attorneys is not necessarily wealthy, although not necessarily impoverished either, but many times they're middle-class people. They're people who saved and did everything right, and then somewhere along the way one of them gets sick to the point where they need nursing home level of care, and we're there to try to help the family manage that and to help them do so without impoverishing the spouse or preserving some sort of legacy for the family, because I don't know many people who want their entire life savings going to a nursing home. So we came from it. I say that as preface just to say, who we were. I got in front of me the reprint of the bill, which includes our amendments to the act. And I've also got the latest draft that we had, although I think they are pretty close. I've taken a look. So I'll kind of walk us through and not read everything, because I think you all have taken a look at things. I do want to say one other thing as far as background is to say that as with the work that you do, the work that we did as a compromise, there were different opinions on things. We had attorneys who bring cases, whose basic business is taking care of people who have allegedly been abused by people under powers of attorney. We also had people on the task force, again, like I say, who practice elder law and people who practice estates and trust. So all of those are different constituencies that we were representing and representing our clients in the best way possible. The other thing I want to say is many of the things that we addressed in the bill are actual problems that we have had with powers of attorney, either from financial systems or from courts. And so there are many of these things that have come out of experiences that we have all had in presenting either the statutory power of attorney or a power of attorney that we've drafted or something that we've drafted into the statutory power of attorney. Or we've had some problem where we have used a statutory power of attorney or one that we've drafted, and it has not authorized what we need to do in order to protect the family. So the first thing I think we did right up front is we said that, this is, we put a warning on it because we knew what we were doing was adding additional power to the agent within the power of attorney. That's the first thing we did. And then the second thing we did, there is a statutory already in the law. There is a document that is in statute along with the statutory powers of attorney that one can give to the agent to explain their duties. But from our experience, not many attorneys do this. As a matter of fact, not many attorneys know it even exists. So we put some information in there for the agent right up front so that even when they see this document, they're going to know that they're not here for their own benefit. They're here for the benefit of the principal, their loved one, probably their parent or their spouse or some other loved one. The next thing we addressed was power to appoint a successor agent. Now, we had done several drafts going through on changing the way successor agents are chosen. Many of the attorneys—
I'm going to chime in 1 second.
Too complicated.
Can I just stop you for 1 second?
Yeah, go ahead.
I just want to make sure people, if you're looking at the reprint, you just went over that first part. I believe it's on page 2. Previously, it looks like it's page
2, starting at line 18, 17,
right.
And 18.
And now you're on page 3 at the bottom.
Yes, I am. I'm
So
sorry.
I just want to make sure if people are looking at it, they can know. Okay, thanks.
So if you're reading along with me, we're now going down to the bottom of page 3 after line 28 and inserting—
Mr. Chair, that was my question. So thank you for that. I just wanted, can you also read the subtitles you want? Because I have the bill. I just want to make sure I'm on the right bill. Thank
Okay.
you. On the right printed, copy of the bill.
Yeah, we're on the reprint number 2. It should be reprint number 2 is what you have. And we are at underneath line 28 on page 3.
Yeah. So the next thing that we settled on and we thought was essential was being able to have the agent appoint a successor if this comes into play where one's loved one may have dementia. They no longer have capacity to appoint an agent on their own behalf. But if their agent gets sick or is unwilling to serve for some reason, maybe they might be unwilling because their spouse is sick and they have to take care of them and they can no longer do these duties. Or they may have moved across country and it may be very hard for them to do. Or they may have gotten sick themselves and can no longer do it. In this instance, barring going to court and pursuing a guardianship, we have no means of caring for this older loved one. So that's what this is about. Underneath that, there is an allowance for compensation. At common law, the default is that the agent is allowed to receive reimbursement for expenses, but not compensation for their time, energy, and effort. But with many agents, especially in powers of attorney that are drafted by other attorneys, especially for people whose agent may be doing an awful lot of work, compensation is something that they authorize. And again, this is optional. It's not required that somebody do this. It's a checkbox. So one of the things that we did was have places within the document that are going to require somebody to affirmatively say, yes, I want that. Similar to what people have to do with the limited power of attorney. The next big change happens on page 5 of the reprint, underline 3. We incorporated the definition of tangible personal property from the limited power of attorney. And remember at the beginning, I said that many of the things that we have done in the document come from actual problems that attorneys have had and have had to go to court for. One of those problems that we've had is that certain financial institutions and courts, depending on the judge, have said that a motor vehicle or other document that has a title is not tangible personal property for purposes of the power of attorney. And that in turn requires additional expense on behalf of the family to take care of their loved one, and time, because courts move at their own pace, and it's not something we can control. So like I said, we've incorporated that and then just clarified that it also includes cars, boats, airplanes, and any other thing that might have a title document that is not a house. The next change that we have is over on page 6, starting at around line 26. Maybe this may not be ours. Actually, I don't think this is ours. I think this is part of the original bill. I apologize. The next change is,
please feel free to just comment on what it does in case anybody wants.
Okay, sure. So this is I think this was actually part of the original idea here, when it says perform the acts necessary to enable the principal to qualify for a benefit or program, including obtaining personal and financial records, and to the extent authorized in special instruction below, to transfer a gift of the principal's property. I'm not sure that this language is necessary with our amendment, just because this is broader language that came in originally. Some of this language may not be necessary, and I'd have to go back through and double check how much of it is actually necessary now that we've covered it in other areas.
Let me stop you there. Is it problematic or is it not necessary?
Well, the phrase special instructions below is problematic because that's no longer in the special instructions section. Otherwise, it may be superfluous, it may be problematic, and I'd have to double check language against each other.
If you don't mind getting back to us with that would be great.
I'd be happy to. Okay. The next big change, and this is stuff that we did. This starts over on page 7 after line 39, and it's entitled Trust and Estate Matters. And these are matters in which generally, let's see. Okay, so these
My
are
copy says
matters.
digital assets. I'm sorry. Is that the same thing? Sorry to interrupt. It says digital assets, line page 7.
I don't see the word physical assets. Where
You're-
are
you're
you at?
at-
I'm sorry. Neil.
After line 39 on page 7, is that where we are?
That's where I have. That's my version of the reprint,
Yep.
and I just printed it from.
So does it start with rights on line 39 says rights or interest? That's the final.
Oh, it starts immediately after that. In all caps, it says trust and estate matters with respect to this subject, and then 1, 2, 3.
Yeah,
Yep.
I don't have, that's page 7.
So we need to make sure that Delegate Tolles is looking at the reprint number 2.
It says into at the top.
So let's see. This should say it should say 18383227/1 is the amendment.
Okay, so I'm looking at the bill. I need to look at the amendment.
Yeah. Oh, you're looking at the amendment. No, we're looking at the reprint.
Right. I think someone, Delegate Phillips got a good point. Could you share on the screen and we could?
Yeah.
That's a
Matt,
great
will you
point.
just share on the screen?
Yeah, that would
Thank
probably
you.
be easier for everybody.
Yeah,
So we're all
Thank you. Mhm.
Sure. Which one, John?
The amendment number 2. It should be I think it's the
But do you want the reprint number 2?
reprint.
think
It should be the last attachment that you gave. Final reprint number 2.
Okay. Thank you.
While we're waiting for that, are there any questions about anything that we've discussed thus far that we might want to get to before we go to this part on page 7? No questions. Great.
I do. Sorry, I do.
One question. Why don't we do that now, Mr. Wilson, and then we'll go on to the next one.
Okay.
Thank you so much. This is so helpful. I just want to make sure I understand the compensation issue, what currently has to happen for an agent to receive compensation and how that changes.
Well, an agent, the principal has to say they can receive it, and under this, they still have to say that the agent can receive compensation.
Okay, so that's not really changing. It's just putting in.
It's not changing it. It's clarifying. It's putting it in the form.
Okay.
So the
Thank you.
form specifically states that you have to opt in to compensation.
Yeah. So you're not entitled to it.
Go down. It's, I think,
You're
page
not entitled
4.
to compensation without somebody saying yeah, without the agent's principal saying yes. Now you're still not entitled to it with the amendment that we've done. We just put it in the form to make sure that people know it exists.
Thank you.
Are there any other questions about anything that we've gone over so far? We're now on page 7 of the reprint, second half of the page. Great. Go for it.
Okay, sure. So when we're talking about trust and estate matters here, we're generally talking about a matter in which the principal is a beneficiary either of a trust or of an estate or some other arrangement that sounds like trust or estate. I'll give you one example. I had a client for whom his sister had a special needs trust. If she couldn't manage the trust anyway, but she was going to be eventually, her health would deteriorate to the point of losing her voice and losing her ability to sign. We executed a new power of attorney because the bank looked at the existing standard form and said, no, it doesn't cover this. What we had to draft was something from the limited power of attorney into special instructions that said that the agent could act on behalf of a trust that the individual was a beneficiary of, so that the agent could say to the bank, who was the trustee, my sister needs X, whatever that X, Y, or Z might be, medication, specialized transportation, whatever the needs of the special needs trust would cover on her behalf. She would have no way to communicate that. And there was nothing in the standard power of attorney that would allow her agent to communicate with her trustee about those needs. So it addresses that issue for one thing. It also addresses other issues with relation to changing trusts for which someone is a beneficiary, pooling trusts. I'm not sure if you all are familiar with the idea of a pooled special needs trust. The Maryland law authorizes what's called a pooled special needs trust, which allows a nonprofit organization to manage funds on behalf of someone who is in need of benefits, would benefit from a trust for their benefit, but the trust is too small for a corporate trustee, and they don't have family to manage it. So there are organizations, there are a couple, 3 organizations out there that will manage a pooled special needs trust for them. So all of these things, in fact, if you look down at number 3 under there, my agent may create and transfer property into an inter vivos revocable or irrevocable trust for my sole benefit, that upon my death distributes property in a manner consistent with existing estate plan, if any, and in accordance with Maryland law. I'll translate that into English.
Sorry, is there some way to like make this bigger? Sorry, is it just me or am I just the only one that? Okay, that's better. Thank you.
All right. So number 3 there, I'll translate that into English. It allows the agent to create a first party special needs trust for the individual that distributes upon that individual's death, first to Medicaid, who would get reimbursed. And if there's anything left over, then it would be in accordance with that individual's existing estate plan. We use this language that's a little bit more broad because we don't want to draw too much attention to the fact that that's what we're doing. And we want the language to be broad enough so that it can encompass other needs.
Just very quickly, so if somebody is trying to use this form and they're not a lawyer, are they going to?
They're probably not going to deal with this section at all.
Okay.
I seriously doubt that anybody other than a lawyer is going to know that there is such a thing as a pooled special needs trust, or the rules regarding who can establish a first party special needs trust on someone else's behalf and when that can happen.
Mm-hmm.
I mean, before I started doing this area, I certainly didn't know they existed.
Okay.
And I've been a lawyer for, 20 something years, 25 years, something like that.
Mr. Wilson, would there be an opportunity to maybe put something in the language at the end of that paragraph that maybe talks about that special needs?
It's in there.
It is?
Yep. So the irrevocable trust for my sole benefit is a special needs trust.
Okay.
It's there. That literally that I'm translating the legalese into English, and that's what it is.
Okay. Thank you.
So all of us knew that's what it was, and that was the language that we came up with. Um,
Question.
yeah, go ahead.
Yes. Helen Conway.
So why are we trying to hide the special needs trust category?
We're not trying to hide it so much as we're just trying to make it broad enough so that if there is some other type of thing, for instance, we also authorize a revocable trust for someone's benefit if they're well enough to be able to manage their legacy plan through a revocable trust, which is the kind that many people do in order to avoid probate. But an irrevocable trust is generally used for other purposes, whether tax planning or planning for long-term care needs. So it's generally used for long-term care needs.
Okay, did you said that, this is Conway, you said that before you started doing this, you weren't really aware of it?
No, I was not, because so I'll give you a quick on my background. For the first, I was a lawyer in private practice, well, doing document review in downtown DC for about a year. And then I worked for the Department of Legislative Services for about a decade. And then I worked for AARP for about a decade. And I've been a lawyer in private practice for 7 years now. So before I did this, I knew a lot of stuff about a lot of things, but I didn't know this.
I mean, but does that justify how you're feeling to not really bring attention to this?
It's not that we're not bringing attention so much as we're making sure that it's broad enough that it captures all the needs. If we said only one thing, it would only, if we say, we authorize X, then Y or Z are not authorized, and we'd have to go to court to get Y or Z, if that makes sense.
Yes, that makes sense. Okay, thank you. That's good. That's good. Thank you.
And again, I have a client who's been waiting for over a month since filing to have a special needs trust for her child for his inheritance.
Okay, thank you.
And she calls me, every 3 days to say, we really need that money. And I say every time, I've given the judge everything the judge needs to make a decision, but I'm waiting. It's up to the person in the robe.
Yes, I understand. Thank you very much.
You're welcome. The next section is where we addressed the issue of what we call gifting. And this is transfers of property in order to qualify for public benefit. Generally speaking, there might be other needs of gifting, but generally speaking, it's transfers in order to qualify for public benefit. And what happens when we do this, under current law, if the agent is authorized to do so, and if the person is capable of doing so themselves, is they give a gift, they incur a penalty intentionally in order to preserve some of the assets. And this is where there was a lot of compromise between the elder law attorneys who wanted a very broad authority and estates and trust attorneys who wanted a very narrow authority, and the litigation attorneys who deal with financial abuse by agents, by loved ones, by children of an older person, who wanted to put as many guardrails as possible around any gifting authority at all. So as I mentioned before, this is a compromise document, and this is what happens when we have a compromise. So you have to affirmatively say, that someone can give away your property. And then you have to say to whom they can do so. It might be their spouse. There are some spouses who, for instance, may give away to their spouse their family home or their interest in their family home to qualify for long-term care, because if they don't, their spouse is going to lose the home and their spouse is going to be homeless or have to go rent a small apartment at more than what their mortgage is.
Right.
If they still have a mortgage.
So this allows for that, allows for the agent, the attorney to do that, but they have to make sure that it's specified in the initial documents to give them the authority, even while they're alive.
Right.
Okay.
Many times, I'll give you a couple of examples.
You can just give us one. We want to
Sure.
try and.
Okay. So if someone comes in with their loved one and they say, my dad can no longer make decisions on his behalf, or my husband had a stroke and can't make decisions on his behalf because his capacity has been limited, then we looked at the document and say, okay, does it allow gifting? Can that person give away their property? Because in order to qualify, they're either going to have to spend everything down to zero, or down to the limits, or they're going to have to give away their property and either have it be an exempt gift or incur a penalty intentionally. If the power of attorney does not authorize that, we go to court. And again, court takes a while, and it could be one of two scenarios. One of which is there's maybe one or two transactions that we're giving away that we're dealing with, and we can do what's called a petition for a specific transaction, which is like guardianship light. You have to do all the things of guardianship. You have to get 2 doctor certifications. You have to petition. You have to notify lots of people. But you don't necessarily have to go through a complete guardianship show cause order and then get a subsequent order to liquidate the asset. Or you go through a guardianship proceeding. You have to get a show cause hearing at which counsel is appointed for the alleged disabled person. A guardianship goes into place, and then subsequent to that, you petition again to liquidate the asset. Meanwhile, now during the pandemic, this may not have been a huge problem.
I'm going to cut to the chase, and this allows us to avoid that and expedite matters, right?
And expedite matters, yes.
Okay, so Frank, do you have another question?
Yes, sir, I do. Thank you so much. You said the penalties 2 or 3 times. Can you be more specific about what a person might do and get this penalty intentionally, like to do the transfer? To change
Sure. So under the Medicaid rules, anyone who gives away property is assumed to be giving away that property in order to qualify for a benefit. Whether it's giving their car to their grandchild or, giving away their life savings of $100,000. Sometimes, though, that there might be another legitimate reason for having done so that might not be related to Medicaid at all. It might be because they, gave away their car to their grandson because grandson needed a car and they weren't driving anymore. And they weren't planning on going on to Medicaid, so that's okay. There are other times in which we might intentionally incur a penalty. I use that $100,000 specifically because I can do the math in my head. So say for instance, mom has $100,000 in her savings. She needs nursing home level of care because she's had a stroke. she is not going to qualify for that. Medicare won't pay for it, as you know. Medicaid does, but Medicaid is a needs-based system. You can only have assets of up to $2,500, which is not a lot. And it's a whole lot more than mom has. Mom can give away her assets, probably to, her family, her son, her daughter, or grandchildren. But whoever's getting those assets has to be a trustworthy person, because it's going to incur a penalty. Mom is going to be penalized for that gift. We are intentionally doing this because that person is going to give back a percentage of that in the form of paying mom's nursing
penalty.
home. Yeah, a penalty.
Got it. Okay.
So she's intentionally doing this. That allows the family, that allows mom to leave some of her legacy to her family.
So,
Got it.
so you calling the nursing home payment the penalty?
No, the penalty comes in the form of a nursing home payment, if that makes sense. I may be skipping a step there for purposes of the explanation, but the nursing home payment is a payment that has to be made by the resident.
Which
The penalty is the amount total. So each payment lowers the penalty.
Okay, all right. Okay. Thank
So
Mr.
if
In this
mom
section-
has, the Medicaid rate is $10,100. The penalty divisor, I think, is $10,119, give or take a few pennies. And so in that $50,000 amount, basically mom's going to have 5 months for which she's going to be on the hook for payments before Medicaid will start paying for her care. During that time, that family member who has put the money in an account to pay mom back by paying her Medicaid, by paying her nursing home bill, that divisor amount for those months. Does that make sense?
Yes, it does. Thank you very much.
Okay. Okay.
I think
Just wanna make sure.
there's a page in between page 7 and page 8 after the gifts that talks about joint accounts and beneficiary designations.
Uh-huh.
I think that's where we're up to, because all the other stuff, the rest
Yeah,
of
we're still,
part is a
we were
form,
just
right?
kind of we were just kind of going over, we're still kind of in gifting.
Okay,
But joint accounts and beneficiary designations after that. So all of that language there on that first page after page 7 is related to gifting and putting guardrails around the gifting. Many of us who put gifting authority into existing powers of attorney might write it very broadly. This addresses that, those concerns that, hey, wait a minute, what if mom really wanted to give it to X, Y, or Z? She already had an estate plan in place. Is the gift strategy that you're using consistent with that estate plan?
right, and making sure that you're not circumventing her original intent because you've been given the authority to do so, and this allows this creates an ability to have more narrow parameters.
Correct.
Okay. Okay.
And so the next one is on the page after that. It's entitled Joint Accounts and Beneficiary Designations.
Yep.
This again is some area where lots of brains work together to make something work. There are many assets, as you know, that when one passes don't go through probate. That might be a beneficiary designation, like you can designate a beneficiary on an investment account. You can designate beneficiaries on life insurance. Certain annuities allow a death beneficiary. there are all kinds of bank accounts have death beneficiaries. There are all kinds of accounts for which, it's not going through the estate if a beneficiary is named. This allows people to change rights of survivorship on account or other assets that someone has an interest in. Again, it may be something that the person going into the nursing home might be a beneficiary of, and that receipt of money, or even the ability to disclaim the receipt of money, can cause a penalty.
Mhm.
So even if the money only imaginarily touches them, it counts and it causes a penalty. So something has to be done outside of their control in order to keep them from incurring a penalty. And then the issue of joint accounts, opening joint accounts with someone, it authorizes someone to open a joint account, again, only if someone has initialed, so they have to affirmatively agree to this. We see this sometimes where someone under a power of attorney does so, but they're not supposed to. And we put a little warning sentence in there that each owner of a joint account has full legal authority to use the account for their own benefit, and upon my death would become the property of the other owner or owners. So we want, again, lots of different interests that we're trying to balance here. And we knew that some of those interests might want that, because in many instances that might be a poor person's will. To name their son or daughter as the joint owner on their bank account.
Mhm.
And again, the disclaimer language, it can be done. Disclaiming property might be done for tax purposes. It might be done for qualifying for government benefit, for long-term care benefits. There are several reasons one might do it. This language is broad enough to allow for any of those types. Delegate Conway had a question.
Go ahead, Delegate Conway.
Thank you. Why might this be a poor person's plan versus a not poor person's plan, rich person's plan?
It could be someone who has significant wealth that might use a joint account or might use a rights of survivorship. In fact, I mentioned a brokerage account. Most poor people don't have brokerage accounts, but it might be something like that. But it is also one of the informal ways that people who don't have means leave legacies for their children without having to go through probate.
Okay.
They name their child. It can be that they do it for convenience purposes, so that their child can pay their bills on their behalf. It may also be a way that, I want my son or my daughter to have what's left, and I don't want them to have to go through probate court in order to do it.
Right. So in other words, a person that has more wealth might have brokers and stocks and bonds and things like that, other considerations that have other legal people involved in. Therefore, their estate is more complex. That's what you're saying.
Their estate's more complex. This section applies to them too, and it may actually be, especially the provisions regarding death beneficiaries and beneficiary designations.
Okay, thank you.
So
I'm sorry, I have one question. In the disclaimer language, it says that you basically can disclaim any property or assets, excluding any testamentary power I can't,
Appointment?
it's on the bottom, accept any testamentary power of appointment that I currently exercise in my last will and testament. Can you just explain what that means?
It's a tax planning strategy. So if someone is at, I don't happen to write many of these, but lawyers in Baltimore County and Bethesda, Horse Country, and richer parts of Montgomery and Prince George's counties, they do these kinds of things all the time. A testamentary power of appointment is an appointment within one's last will and testament that allows somebody else to do something. And this is basically a tax planning strategy here in order to avoid certain tax penalties that might otherwise apply to
Okay.
someone's estate plan if they're allowed to do something.
I can follow up with you later on that. When I'm rich, maybe you can help me draft some of these, right? Okay.
I know guys who know how to do this much better than I.
All right. I think that we've come to the end. I don't think that there's anything of substance after this except.
Yeah, I mean, we just there are some provisions there regarding termination, reliance by third parties. I think that one in particular, the reliance by third parties, was in order to protect the banks and financial institutions. Again, if you want to, we threw Bob Ent in the bone. So,
Okay.
and the other provisions in there at the end, again, are issues that we've had. The provision about revocation, if you've drafted a will or seen somebody's will or heard, on television, this is my last will and testament, I hereby revoke all other previous wills. This clarifies that you're doing the same thing with a power of attorney so that somebody else isn't running around with an old power of attorney and, saying, hey, look, it's still valid. They never revoked it.
Okay.
This clarifies that, yeah, actually we did.
Any more questions? So that we have Mr. Wilson here now. Yes, Nicole, go ahead.
Yes, thank you, Chair Carden. So I appreciate all of it looks like a lot of thought and a lot of time and effort went into all of this. And so I just want to just kind of summarize, I think, everything that was being said. So these are just amendments to the standard form that people will have to use moving forward if we move forward with this piece of legislation. And the changes that you're proposing will allow greater flexibility for parties to kind of address some of the real world occurrences that you all have been experiencing in your practice. Is that correct?
That is correct.
Okay. All right. I just want to make
I
sure
think you've nailed it, Delegate.
Okay.
That the every change that we made is because somebody's client had this problem and had to go to court and wait around for months for a judge to make a decision.
Right. Whereas with these new forms, then hopefully the new forms can address some of these things if the parties so choose to do so. And I saw there were certain sections, especially that section kind of on at near past page 8, I guess it was 7, between 7 and 8. That's sort of an optional section. So
it is an optional section. It is something that we don't think most people, if they download this from the AG's website, they're probably not going to do that because they're going to go, why on earth would I want to authorize my agent to give away my stuff?
Right.
But the issue happens when they're dealing with an attorney, and sometimes even when attorneys draft people's powers of attorney, they don't put these provisions in, and then we end up having to go to court and either go full guardianship or something short of guardianship, but it always takes time. It's always stressful. It always costs the client more money.
Right.
And, these are not necessarily rich people. They may have, their greatest asset may be their house, which, we're trying to preserve that for their spouse.
Got it. And then, so this in theory would even benefit lay people if they didn't want to hire an attorney. Like you said, they can go to the AG's website, print this form, kind of fill in the different checkbox that they feel is applicable to themselves, sign it, get it notarized, and kind of call it a day.
They can. We advise them to get.
I know.
We advise them
all
right
the
up
attorneys
front.
on here are
You
like,
should
no, we
really
advise you get
contact
legal
an
counsel.
attorney.
Right.
I had, yeah. The
That-
last
that-
person who called me said, can you send a letter to a bank in South Carolina saying the Maryland power of attorney I downloaded is legit? I'm like, no, I can't until I've reviewed it. I don't know what you downloaded. I don't know where you got it.
That was the intent of Delegate Hill, Delegate Williams, when she originally wanted to do this. So yeah.
Yeah, I think, Delegate Hill was very gracious in allowing us to abscond with her bill. But we have been working on this, like I said. I'll say we've been meeting approximately once a week for the last 2 years to put this together.
No, and I really appreciate the effort. I just want to make sure
And
the
then
attorney in
there's,
me appreciates the effort, but the legislator in me also wants to make sure that this is something that would be easy for just the average layperson to use who may not have the financial resources to hire an attorney like yourself to kind of walk them through this. So that's the only thing.
Okay. We have three more questions.
Okay.
Great points. And then we're going to we'll try and vote on these amendments. Okay, Delegate Conaway.
Thank you, Chair. So does this once a person downloads and fills it out?
I'm sorry, on my end, Delegate Conway broke
You
up.
broke
so-
up, Delegate Conaway.
Once the form is downloaded and filled out, does it have to be notarized? And then would it have to be filed with a copy of it have to be filed with the Register of Wills?
So once it's downloaded, it still has to be it already has to be notarized. It is the document for which I became a notary. That and writing a deed.
Okay.
So, for my clients, I don't charge them extra for being a notary. They've already paid me enough money. But for somebody else, they're gonna, if they download it off the AG's website, they're probably going to go to like the UPS store or their bank or something like that, where they get notary service for a reasonable amount of money or no money at all. If they're, if it's their bank may not charge for notarization.
So once you notarize forms, do you generally send a copy of that to the Register of Wills, or you generally
No.
It's a copy of?
There might, the only time that it's recorded someplace is if the person is using the power of attorney for purposes of transferring real property. In other words, signing off a deed on someone's house. If they're selling mom's house, the power of attorney would be recorded along, a copy of the power of attorney would be recorded with the deed. Or if you had a power of attorney that was specifically for that, say you were, going away on vacation, and while you were on vacation just happened to be the closing time for the house that you're selling when you're buying another house or moving, downsizing or whatever it is, and you have someone else sign it for you, that power of attorney would also be recorded with the deed. The other instance where we advise our clients to take it ahead of time is to their financial institution. It's not required that they do so, but it makes life a whole lot more easy for the agent when their loved one is sick. If the financial institution already has the power of attorney on file and has already recognized it, it's going to be easier for that loved one to take care of their sick parent or aunt or uncle or spouse or whoever that person is, that principal for whom they have a power of attorney. I always advise them, hey, look, take this to your bank, make sure they have a copy, put it on file. Same thing with any other financial institution that you have, go put it on file.
Okay. Delegate Phillips.
Thank you. So my question is really what is, and I know we're doing this, we're providing a standard form. What are the potential implications to lawyers that have their own form that don't necessarily follow this form in terms of industry? Because one of the things that I've noted is once you do the standard form, there are some institutions that may not want to accept a form or a power of attorney that is drafted in some other way. So what are the potential impacts of us as legislators saying this is the standard form?
Good question. So several, one of which is it gets within the standard form. Some things under current law, if my client uses a standard form and their financial institution declines to accept it, we can sue them in court and get triple damages, plus attorney's fees, plus whatever bad press that financial institution's going to get for getting sued because they didn't recognize mom's power of attorney. They don't have that problem for one that I might draft specifically otherwise. So different attorneys have different means of using one or both of the standard statutory powers of attorney. One of which is they draft a standard statutory power of attorney. They may put it in their own font or whatever. It won't necessarily be the one that look exactly the same as the one that's downloaded from the internet. Sometimes, a lot of times, and I will do this, I will put in special instructions. Lots of others do this. I know at least one attorney whose special instructions are his entire non-statutory power of attorney that he had prior to the statutory power of attorney being adopted 10 years ago or 12 years ago, whenever it was, 2010, I think. So that's now 13 years. Other attorneys draft two powers of attorney. They use the standard statutory power of attorney. They use a custom other power of attorney. There's no guidance from the courts as to what substantially similar means. And I know what it means in terms of fiscal notes because I used to draft fiscal notes. And when we talk about a substantially similar bill, it might be a few tweaks. If I draft special instructions, is that substantially similar? So I guess to answer your question, there are still going to be attorneys who might draft non-statutory ones or might draft something similar to the standard statutory power of attorney and might, for instance, ask their client ahead of time, do you want your agent to be able to give away your property to plan for public benefits? If so, I'm just going to put that in. It's going to look substantially similar to a standard power of attorney. And we're going to run it up the flagpole of your bank to make sure that it works ahead of time. So there's still going to be room for attorneys to be able to do what they need to do with individual clients, if that answers your question.
I think it does, but it probably opens up some additional questions. I know what we're trying to do, and I get it. But they're real world scenarios. So there are some banking institutions that will say, we have our own standard form, and we want you to use our form, right? And there are, maybe national banking institutions.
We are familiar with those institutions.
Right. And so
the larger the institution, the more compliance personnel they have, the harder it is to deal with them. And I dealt with them a lot when I worked with a little organization that starts with an A and ends with a P, dealing with the financial services industry. So, and compliance officers are the type of people who take a lot of Tums. They get really nervous about stuff. Again, it goes back to getting the document in front of the financial institution early. Some of them are going to balk because they're large. The enforcement mechanism is to sue them.
And by having a standard statutory language, that would put those persons who have a power of attorney that is drawn up under the statute in a better position. We have more certainty. Is that what this also?
We have more certainty. That is true. We have,
Okay.
We still may run up against problems. And I don't know how many of you all are lawyers. I know some of you are, that the Maryland State Bar Association has listservs of lawyers who can, go down the virtual hallway and ask their colleagues, hey, I've got this problem. Has anybody ever dealt with it? Can you help me? Or help me think it through? Or, have you dealt with this? What do I do? Many of those might deal with national banking institutions or local banking institutions that didn't accept the power of attorney. Not all the time, but they do happen. And if it's the statutory form, we can sue, we can talk up the food chain, we can find a back door to find their compliance people because they're not always transparent at the branch level of finding that. I had one where I was dealing with a bank on a slightly different matter, where I literally had to Google their general counsel to find out who that was, and went through the general counsel's office to try to get the problem resolved. We were able to resolve the problem and save the client a whole lot of headache and money. But it's not easy to deal with large financial institutions. So the larger your financial institution, sometimes the harder it is. But it's not always that way. Sometimes smaller financial institutions or regional ones can be equal pains.
I think we could make the case, though, that if we have the standard form, it will create a better foundation for being able to get all these larger institutions to see legitimacy in these documents and be able to.
Absolutely, it would do that. It is absolutely much better footing. You're correct.
Delegate Phillips, anything else?
Yeah, just one other question, just about process. So I want to be clear. The elder law section and estates and trust did this work group. You're making these recommendations. These was there like a democratic process, and were these like voted out, or how did that?
So it went to the section councils. So of the section, there may be, I think there are over 1,000 attorneys in the elder law section. There are probably a couple of thousand in the estates and trust section. It didn't go section wide, although we did present, and invited members to a webinar on it. There are some members who are, many members are accepting, some members are not particularly happy. It did go to the section councils though.
And so it came out of
the section councils. And in fact, there were, the last draft that I had, there were red line remarks that went back from the estates and trust section council that came back to the elder law section council, who said, hey, wait a minute, one of these things you did just completely obliterated everything else we did. Let's go back and change that language here. And I don't remember exactly what the language was off the top of my head, but I can go find it. We're happy with, like I said, this is as good a compromise as we're going to get.
Okay. I'm just trying to make sure I understand that this was
It is indeed a
Okay.
compromise of,
Thank you.
interests, and we're not, like I said, we're probably not going to please everyone, but we'll please the majority. Probably.
Delegate Tolles, you got the last question.
Thank you, Mr. Chair. I guess I had a question as it relates to the form as well. In terms of the form, this standard form that's being offered, is there assistance? Because you indicated, Mr. Wilson, that, obviously individuals have to do their form themselves. It should be more, user friendly, but I'm thinking about like child support cases where you have a form and there is, I guess, assistance, the child support assistance unit that will help you fill out the forms. Those who are looking to submit the forms to the court, do they have something like that where we can help, where it's user friendly? And and it's part of the conversation is supposed to be, friendly for anyone who is not of significant means that can fill this out and, be able to.
There is some help. I mean, there's not, unlike the child support forms, for instance, where, you've got an agency that does that. This is private form. So there's not specifically a state agency that does so. There is the Maryland Volunteer Lawyer Service, for instance. There are various pro bono programs within each county bar association.
Right. So let me back up. I'm aware of all the county legal programs that they have available. I just wanted to kind of get an idea that if someone needed additional assistance, because you indicated that, hey, we won't be able to obviously fill out the form for them, but like you said, with the child support cases, there is an agency. So there is no, they pretty much have to understand the form or get a lawyer.
Yeah. I mean, they may use, like I said, there are people who download the form right now and they use it and it works for most of what they need it for. I don't think most people, when they download this form, just based on my own experience with, my own family and others who are reasonably intelligent human beings, but don't practice this kind of law, or probably aren't, and many of them aren't even lawyers. They wouldn't be putting in some of the things that they wouldn't be checking off boxes for things that we put in as check boxes.
Mr. Chair, should we move the amendments?
Second.
Hold on one second. I had another question.
Yeah. Okay.
Thank you.
Delegate Tolles, yes, we'll have your questions. There was a movement of the amendments in a second. So
I understand that, but
now more questions. Delegate Tolles, go for it.
Thank you. It was just, can we just wait until I don't like when you do that. It just really is kind of annoying. I get it. And I'm going to be really quick. So I'm trying to get Mr. Wilson to answer the questions as succinct as possible. But I would like to.
You have the floor.
Right. I would like to, just in the future, I would like to get through my questions before a motion is made. I think that's the respectful thing to do. I would agree, and
I will make sure that the people that did that will be reprimanded appropriately.
Vice Chair Moon should definitely be reprimanded. I just want to understand that I have a situation where a neighbor, I just want to, ensure that this will be beneficial to, a scenario what they have experienced, who have a son. The parents had a son who had a stroke. And so, obviously it was unexpected health emergency and they were not able to get the necessary forms. Like, he's an older adult. He has, a child that's of age that can do it as well. But I wanted to be able to see in that situation where he could not talk, he could not walk, they're doing all of his medical care, getting now the, Medicaid, Medicare forms, all of that filled out, but he can't write. In that situation, will this be able to help them if the person that should have completed the forms ahead of time was not able to do so?
That depends. So it depends on whether you said it was their son.
Yes, it was their son.
Okay, so and it's an adult son, right? I have exactly that problem with not a son, but a spouse.
Mhm.
And my client called me initially and said, my husband had a stroke. I need a power of attorney. I said, can your husband consent? I don't know. He can't speak and he can't. I said, well, can he blink once for yes and two for no? Can he understand? Because he might not be able to speak, but he can still understand. Can he at least say that?
Mhm.
No, he can't. He right now he was at that time vegetative state. He's no longer in that vegetative state. But if you can't consent, you can't do a power of attorney, because a power of attorney is a consent document. You have to want it. You have to want it. If you don't have the ability to do that, then you're left with either a guardianship or something close to a guardianship. And guardianship is unfortunately more expensive, but it's the only way to deal with someone who can't consent on their own behalf.
Okay, so in this situation, yeah, I know he could blink, but now he is unfortunately blind. So where he could do the one blink or two blinks, he's now, needing, a little bit more care and having some other health challenges. So as we look at layman's, way of, Marylanders being able to complete forms and have, assistance, and this being a user-friendly, way to do that. I don't know, and this is, something I can obviously talk to Delegate Hill about. How do you make it easier if you have a situation where an adult parent has to do, take care of an adult child now and trying to. So I had to I ultimately ended up referring her to someone who could. I told her I don't have a lot of estates and trust from background, but I can refer her to someone who could. I had to do that. But if we're creating change in Maryland, I want to be able to assist a situation like that, because we have more folks that are serving in caregiver roles now.
I identify with that completely. I know exactly, not just from client experience, but from personal experience. My wife was on a respirator for about 3 weeks in the beginning of the pandemic, not because of pandemic, but because she had an autoimmune disease that left her completely unable to speak, unable to breathe on her own. The only things she could move were her fingers and her toes. Those were the only muscles on her body that she could operate.
Right.
Kind of hard for her to work around that, and really had to work, through me to be able to consent to her treatment and care.
Okay.
It is very difficult. And if somebody can't consent, we're left
These forms
with,
gonna be helpful then.
we're left with something more drastic.
Okay, thank you.
Tulsi, good, great. Delegate
Yes,
Conaway,
thank you.
really quick, because I know that we got everybody, but we need to move on. So go ahead, but you got one more question. Go for it.
Yeah, I think this is an important issue. When the marriage equality issue came up, one of the points was that if the couple wasn't married, then the property could be challenged by, let's say, one of the spouse's parents. And if the couple was married, then the property, if something happened to one of the members in the couple, the property would automatically transfer to the other member. Or if they were medically incapacitated, the other member that they were married to would be able to speak for them. But now you're saying without this kind of official agreement that's not accurate? Is that what we're saying?
I don't know that it is and it isn't. So I think first thing we need to do is we're merging the discussion of medical decision-making versus financial decision-making. And when we execute documents for people, they're separate. There's two separate guardianships, for instance. There's guardian of the person that allows you to tell where somebody lives and, whether they take medication and what doctor they go to and all those kinds of issues, daily living and financial.
I'm talking about
power.
I'm talking
The
about
same
the
thing with the
financial-
power of attorney, though.
Chairman's
You
getting
have
upset.
two different, this this is a financial document. It
Yes,
only
so-
relates to someone's finances.
Right.
So
if
it
the house-
doesn't relate to,
Right.
medical
the house-
decisions.
If the house is in one of the spouse's name and something happens to them medically,
Mhm.
then does that house revert back to the other
This is,
spouse?
So until that
if they don't
spouse
have-
dies, unless they have a power of attorney in place that allows their other spouse their spouse to transfer the asset, then it's still in that ill spouse's name until that person passes. What happens to it afterwards has to do with, trust and estates law. It depends on whether they have a will. It depends, and if they don't have a will, then it goes to the state's default will, which is called intestate succession, and that depends on family situation. It depends on
that's outside
whether
the
they have
scope of
children.
thi- of
Yeah, it's
this.
outside the scope of this. It depends on whether they have children. It depends on whether their children are minors or adults. It depends on how long they've been married. It depends. There's lots of factors there.
Okay. All right. There is a motion favorable on the amendments and a second. All those in favor of the amended version, this amendment, raise your hand or put your hand up in your Zoom. 1, 2, 3, 4, 5, 6, 7. Great. Anybody opposed? Anybody opposed? Mr. Wilson, I'm going to just say that you guys did some tremendous work. I know this was a huge compromise, and it took 2 years to get everybody on board. And I know that not everybody was on board, but it seems like you have a significant majority of people that appreciate the fact that you guys brought all these people together, and the bar is coming in supporting this as a great piece of work. So thank you for all your time. My sister is an elder care attorney, and she is thrilled that you guys did all this and spent your time and got this done. So,
Well, then thanks to her and to my delegate who's on here, or at least
Okay.
one of my delegates.
We now have passed the amendments. Is there a motion on the bill?
Favorable.
Is there a second?
Second.
All right, very good. All those in favor of the bill as amended, please raise your hand. Is there anybody opposed? Nobody. Delegate Williams, are you opposed? Okay, very good. And Delegate Tolles, are you opposed or you have a question? Neither. Okay. Thank you all very much. Thank you, everybody, for the hour and a half that we spent on this. And thank you, Mr. Wilson. Please, can you make sure, I want to make sure that when everybody else goes off, let's stay on for a minute. I want to get your contact information because I may need to have some training if I'm, for this bill and understanding of some of the nuances, just to make sure I'm very familiar with it. All right, everybody, we're now
Yep, there we
adjourned. We're now adjourned, but Matt, just keep the Zoom open for a second.
Thank you so much.
Thank you.